broadcast, share this video to your loved ones, people who might benefit from it if you are not directly affected by this evening's topic. This evening, we are going to talk about settlement application for children and young adults. We are calling them young adults because they are within the age bracket between 18 and 25. So if you live in the UK as a child below the age of 18 and also between the ages of 18 and 25, and you don't have any leave to remain in the UK, or you are on a particular route into indefinite leave to remain, please try and listen to this important information or education that we're going to bring your way. You are watching You and Your Right, and it's brought to you by Fortwo Solicitors. Fortwo Solicitors is a law firm based in the UK. We specialize in specific areas of law like immigration, family, employment, civil litigation, wills, and probate. We dedicate ourselves to you every Monday. We come your way with topical issues that might affect you or your loved ones. In this evening's program, we're going to talk about settlement application for children and young adults. Please get a cup of tea, call someone, let someone know that You and Your Right is life, and it's brought to you by Fortwo Solicitors. We're going to go for a quick commercial break, and when we come back, I'm going to introduce to you our guest for this evening's program, who is going to assist us in dissecting this particular topic. So take this opportunity to share this video to someone, grab a cup of tea, cup of water, and we're going to be right back. Thank you for watching. Hi, welcome back. I am Patrick Opokubuaten, your host for this evening's program. And I've got in the studio one and only other one of our senior solicitors at Fortwo Solicitors, who is going to assist me in trying to deliberate and talk about, discuss this particular topic, because I know there might be many people who are affected by this and they might not even be aware of it. So I'm very happy to have this gentleman with us, a solicitor by profession who works at Fortwo Solicitors. Lawyer, if you can introduce yourself to our viewers this evening or wherever the time there is that they are watching us, from? We cannot hear you. No. Okay, so our guest is trying to sort himself out, and he's going to be back with us sooner than later. Don't go away. At this moment, there is a bit of a technical issue, but that does not mean that the program is just gone to a halt. As I introduced earlier on, this evening's topic is about settlement application for children and young adults, people who are between the ages of, when we say young adults, in this particular topic, people who are between the ages of 18 and 25.
Can you
There
hear?
is many people who obviously are in the UK one way or the other. Okay, yeah, he's back. Let's
Yeah,
hear
can you hear me
you
now?
now. Oh yeah, I
Can you
can
hear
hear.
me?
We can hear you loud and clear.
All right,
Thank you,
thank you very
technical
much.
team, for sorting you out. Please, can you introduce yourself?
Thank you very much, Lawyer Patrick. My name is Lawyer Daniel Coy from Football Solicitors. And as you rightly said, we specialize in immigration matters. Apart from immigration, we deal with family law, civil litigation, employment, and wills and probates. When it comes to employment or immigration issues, we deal with any aspect of immigration from business migration to private migration to asylum issues. We deal with all of it. Even within that, we deal with appeal matters, judicial review matters, entry clearance application, meaning those who want to make application from outside the UK. And these are my areas of specialty. So I'm more than happy to join you today in today's discussion where we talk about settlement applications for children and young adults. Thank you.
Thank you very much, Lawyer Daniel Coy of Photo Solicitors, for joining me again on You and Your Rights every Monday. If this is the first time you are watching us, please make it a date, and every Monday from 7 p.m. to 8 p.m. Let's discuss important topics that might affect you, your friend, or your family. So, this evening's program, we're going to talk about settlement application. As I was saying earlier, there are children and or young adults in the UK who are not born automatically as British citizens, because in the UK, past long gone, if you are born in the UK, you don't automatically acquire or you don't automatically become British citizen. So, what type of leave would you be granted? At what age? At what time in your life are you able to obtain or to be able to make an application for a specific type of leave to remain? Ages, times have passed, gone, immigration rules have come, changed, and now, just only about few years ago, the UK government changed and they brought some policies for children and young adults to be able to make a specific type of application in the UK to be able to qualify because they satisfy certain requirements while they are in the UK. These are the people that we are going to talk about them. These are the children, these are the young adults that we're going to talk about them. So if you fall into that category, you are below the age of 18 or between the ages of 18 and 25, and you were not born British, whether you've got a type of leave to remain at the moment or you don't even know the type of leave to remain to make application for, then this is a topic for you to drop by so that you get educated. And as we always say, this is just for educational purposes. If you need further clarification or if there are certain points that we raise that you think that it may affect you directly, give us a call. Your first initial consultation will be free of charge for you. Lawyer Dan, I've just given a bit brief about this particular topic that we're going to discuss. I know that there are history behind this particular settlement application concession that probably would have just been introduced, I think, back in 2021 or so. So, can you tell us a bit about what brought about this particular settlement application, or what are the types of application for children who were born in the UK, who came to the UK as children, those who are between the ages of 18 and 25? What are their circumstances and what are some of the changes? If you can give us a brief idea so that people will get the gist before we get into the nitty gritties of this topic.
Yeah, can you hear me, Lawyer Patrick?
Yes, we can. We can.
Okay, I'm having a bit of challenges hearing you, but if you can hear me and our listeners can hear us, that's the most important part. As you rightly said, in today's topic of discussion, it's really related to young adults and children who may qualify for early concession to indefinite leave to remain, or who may be leading up to that, they can get their British passports in early stages. And for those of you who may not know the background to this. This was introduced somewhere around November 2021. Prior to November 2021, we had the old rules whereby people who, um, Laura Patrick, I think, can you hear me? I'm really
Oh yeah,
having
yeah, we can hear
challenges
you
hearing you.
clearly. Yeah,
Oh, okay.
yeah, it's clear.
Yeah.
Yeah.
I think prior to this, that we had the old rule, which was around 2012 when this was introduced. And when it was introduced, young children, which is defined between the ages of 18, or young adults, which we define it as between the ages of 18 and 24, that is below the age of 25, could make an application to stay in the UK if they have lived in the UK for more than half of their life. And what that happened was they will have to be able to make an application under the 10-year route, meaning they will get 2.5 years, 2.5 years. And after they've stayed in the UK for 10 years, then they can make an application for indefinite. This is the rule as it was from 2012 till 2021 November, when the government decided to make an amendment. And when they did make an amendment, they did not just leave it at the young adult section. They also made a few amendments to children who may qualify under the what we term as Appendix Private Life. And for the children, what the Home Office or the government said with the changes that was determined or that was made was children who have normally been born in the UK and who have lived in the UK for 7 years, instead of them having to make an application for 2.5 years and 2.5 years, they can straight away make an application for indefinite leave to remain at that age, which was brilliant because before this, the parents of these children will have to foot up the bill of making renewal for 2.5 years, 2.5 years for 10 years before they qualify for indefinite. For most people or for most children, once they reach the age of 10, they would also qualify to register as British nationals under the different British Nationality Acts, which helped in a way. But those who were not aware or who could not afford it at the time will normally be renewing every 2.5 years till they are 10. The other aspect of it is there may be people who are below the age of 18 years but were not born in the UK. So even though the 10-year route, which allow them to register for British nationality, will not apply to them, that meant that they had to be paying those bills for 10 years before they qualify. So that was very helpful. So for people who are below the age of 18 years but more than the age of 7 and were however not born in the UK, they could also take advantage of this rule, meaning if they have lived in the UK for more than 7 years of their life, they can, of course, make an application for indefinite leave to remain. Um, Lawyer Patrick, clearly, we all know, as it always turns out, that whenever these things are introduced, we can describe it in simple terms that this group of people can make an application, these people can make an application. And as in this case, we have clearly stated how it was in the old rules and how the new rules works in this situation. But clearly, there are certain aspects that need to be met before such applications can be done. And one of them is what we will term as the eligibility requirements for settlement after 5 years. So, if you can take us through that aspect, whilst I try to fix my hearing issue, that would be great. In the meantime, I hope everybody can hear me. But the eligibility criteria is very, very, very important, because without that, any application that you are making is going to be a challenge. So, Lawyer Patrick, please tell us a little bit some of the conditions that need to be met before somebody can make an application and qualify under the eligibility rule that the Home Office published.
Okay, thank you very much. Yeah, we could hear you clearly. I don't know whether you can hear us clearly, unless you think that you still have to go back and sort yourself out. But we can hear you clearly. Okay, so as Lawyer Daniel just mentioned that that basically there is a history behind this particular type of application. It started before 2012. In 2012, it was incorporated into the immigration rules, and it became a private life issue for people or children and young adults who were born here. As I mentioned initially, if you were born within a specific year in the UK, think before 1981, you are not automatically British. Therefore, there should be a type of leave for you to remain in the UK. Before 2012, there used to be indefinite leave to remain for children, like people like those that we are talking about now. Then back in 2024, the immigration rules changed and they became part of what we call private life for people who were born here and they are 7 years and who are children below the age of 18. And during that time too, they incorporated the young adults too. What that meant was that if you are a young adult and you were not even born in the UK, you came here as a minor and you are between the ages of 18 and 24, 25, and you've spent half of your age in the UK, you are eligible to make an application based on your private life. And as Lawyer Dan said, you would have been granted leave to remain for 10 years, two and a half, two and a half, two and a half, four times before you will qualify for your indefinite leave to remain. But just back in 2021 in October, the Home Office gave a concession to people who were born here and they've spent 7 years of their life. So if you were born here, or if you have a child who was born in the UK and the child is 7 years or is going to turn 7 years, what the rule or what the concession brought about back in October 2021 was that you do not have to qualify for your private life and obtain 2.5 years for 10 years before you get your indefinite leave to remain as a child who is below obviously the age of 18, born here 7 years. Automatically, you qualify for your settlement. Let me break it down again because probably you didn't hear me clearly. If you have a child who was born in the UK and have spent their lives, 7 years of their lives here in the UK, automatically, when they hit the age of 7, there is a concession from October 2021 that that child automatically obtains their settlement in the UK. That is indefinite leave to remain. That's it. That is the immigration rules. End of. There are other people too, we are terming them as young adults as well, who are also qualify to get their indefinite leave to remain if they are between the ages of 18 and 25. Their eligibility are also on their way coming that we are going to deliberate upon. But the young ones before the age of 18, born here 7 years, your eligibility is that you have to have been born here in the UK. You have lived your life here in the UK for 7 years. Automatically, you qualify for your indefinite leave to remain. The young adults are the ones that are between the ages of 18 and 25. And you would also qualify, or you are eligible to make an application if you are between the ages of 18 and 25. That is one eligibility. You have to be between the ages of 18 and 25. So if you are below 17, you are not eligible to make an application for settlement as an individual under the young adults concession. The second eligibility is that you have to have lived here half of your age or half of your years in the UK. Let's say, for example, you came to the UK at maybe at the age of 4 years, and you've lived here in the UK for say 15 years. Now you are 19 years. You came here at the age of 4, you've lived here for 15 years. So you are 19 years old in the UK at the moment. You don't have any leave to remain because obviously you've not even heard. Probably you might even be thinking that you are British because your accent will be like someone who was born here if you came here at that age. But in fact, you don't have any leave to remain in the UK. You have to have made an application for leave to remain in the UK before you can even travel outside the UK. Because if you venture and you go out, you might not be able to come in. Meanwhile, you've spent 15 years of your life here and you are 19 years old. You are under this concession for young adults. To be able to qualify, you should show that you are between the ages of 18 and 25. Yes, you are 19 years. You should also qualify or you should be eligible to make this settlement application because you have spent half of your years here in the UK. Half of 19 will be about, I think, 8 times 2 is 16. 9 times 2 will be 18. So you will be about 9.5, or let's say between 9 years of your age. 19 is more than how long you've lived in the UK. Therefore, you qualify because you have spent half of your years here in the UK. I guess you get that calculation. You were born here, sorry, you came to the UK at the age of 4. You are now 19 years. It means that you've spent 15 years in the UK. Half of 15 will be about 7.5 or so. But when we calculate it, it is more than 9 years. Therefore, you spend more than 7.5 years of the age that you arrived here in the UK. If you need further clarification of this half of your years, you can call for two solicitors and we will take your specific age and we will do the calculation. The date that you came here, you were not born here, you came here, say, at the age of 4, you spent 15 years here, you are now 19. We will do the calculation. And if you spend more than half of your years in the UK, then it means that you qualify for settlement application in the UK. Again, there is another eligibility that you need to satisfy. You were born in the UK or you entered the UK as a minor. That is one of the requirements. You must have entered the UK as a minor. A minor meaning, for example, the 4 years old that I've said, or maybe 5 or before the age of 7, you are classified as a minor. You are eligible if you are under or if you are between the age of 18, 25, you have spent half of your years in the UK, you qualify. So the eligibility, you need to satisfy them one by one to be able to apply for settlement application here in the UK. Another eligibility will mean that you would have held or you are holding a 5-year leave to remain in the UK, at least 5 years leave to remain, because at this point, if you had not made an application or if you didn't even know that you qualified to make an application based on your private life before 2021, because when we started the program, we gave you a bit of history. Before 2021, you would be applying for leave to remain based on your private life here in the UK. And you would have been granted 2.5 years, 2.5 years, 2.5 years, 2.5 years, 4 times to obtain 10 years continuous leave to be able to make an application for indefinite leave to remain. But from October 2021, there was a concession. So, as part of the eligibility, you should have held at least 5 years of limited leave to remain before you will be able to apply for your settlement application as a young adult. That is someone who is between the ages of 18 and 25. Another eligibility amongst the other eligibilities that I have mentioned earlier on is that you have a further leave to remain, a life further leave to remain. So what that means is that at the point that you are making the application, you shouldn't have been an overstayer. There shouldn't have been any situation whereby your leave to remain that you were holding before the October 2021 had expired because of one reason or the other. There should be, you should have been eligible to further leave to remain in the UK. If for any reason you will not be qualified for further leave to remain in the UK, you cannot apply for the settlement application for young adults as we are discussing at the moment, amongst the other eligibility that I have already mentioned. Again, you were eligible if you held a visa based on your private life for at least 1 year in the UK. So you are between the ages of 18 and 25, you are eligible. Again, we will go down and say that you have been in the UK half of your years in the UK. You were not born here, you came here at a particular age. When we take the number of years that you spend here, when we divide it by 2, it is more than your age. Therefore, you qualify for your indefinite leave to remain or your settlement. Again, you were born or you entered into the UK as a minor. You also qualify for the settlement application that we are also talking about. And as I mentioned, you hold or you've held a 5-year limited leave to remain in the UK. There is also eligibility criteria that you have satisfied. You have a further leave to remain in the UK. You are holding a visa based on your private life in the UK, and it's for at least 1 year. You also qualify for settlement application in the United Kingdom. When you satisfy all this eligibility, or if you are someone who think that you fall into some of this category of young adults that I am talking about, there is a possibility of us making an application for you to be able to qualify to obtain settlement in the United Kingdom. When such an application is made for you as a young adult or as a child, because you were born here in the UK and you've lived here for 7 years of your age, then you qualify for indefinite leave to remain. When we make that application for you, there are other considerations that the Home Office would have to take before they grant you the settlement application. You might be eligible, but the Home Office or the caseworker would have to take further consideration on certain things or certain criteria that you probably might have may have affected you or your parent or your guardian whilst you were in the UK as a child. Because the people that we are talking about now are people who were not born automatically as British. They would have come here as minors. They would have come here, or their parent, or yeah, their parent would have come here and given birth to them. Obviously, the parent will not have leave to remain. Therefore, their children will also not have leave to remain. These are the people that we are talking about. So the Home Office, apart from the eligibility, they will also take certain things into consideration. One of the things that they will take into consideration, most especially for the young adults, is if you are eligible and you are able to make that application, they will find out or they will see whether, amongst other things, what lengths have you got in the UK. Say, for example, a young adult is come to the someone came to the UK at the age of 5 years, 6 years. Maybe the auntie invited him or her. Now the person is 21 years. They even wanting to go to college from maybe the age of 18 or 19, and they are not able to because they don't have leave to remain in the UK. And what I'm talking about is real, it's happening. There are people who were born, there are people who were brought here by their aunties or their uncles, or even their parents even came here, and one way or the other, they left them with relatives, and now they are young adults. They want to further their education. They don't know how to go about it because wherever they go, they ask them, bring some sort of leave to remain here in the UK. If you facing that problem, or if you know anyone who is facing this kind of problem, and as a result, they are not able to educate themselves or even take up jobs, travel outside the United Kingdom, then probably this topic will be very relevant to that individual that you need to send to them. So they will now look at the links that you've got here in the UK as a young adult, whether you are having parents, one of the parents probably here, you've got your aunties, your uncles, you've got your cousins here, you've maybe at least schooled here a bit. Therefore, you have links with friends, acquaintance, maybe church members. The Home Office or the caseworker will take into consideration all this and wanting to find out whether you will be eligible. In fact, I've just seen that our time is fast spent, and other people might would want to obviously take a short break and maybe fill their cup with some water or fill their mug with some tea and refresh themselves and come back. So I'm just going to have a quick commercial break. And when I come back, hopefully at that time our guests will be available. We will go into the other consideration because apart from you being eligible, the Home Office will have to take some of these things into consideration to come to a favorable decision. So it is very important that we take this part, the next part of the program, very seriously. So don't go away. We're just going to go for a quick commercial break. And when we come back, we'll be talking about the other considerations that the Home Office take to make or to grant you a settlement visa in the UK. And we also talk about the benefits of the concession back in 2021, what is done for you and I. And even if you've not even benefited from it, what are some of the benefits that you will gain if you have this knowledge that I'm going to share to you? So stay tuned. We're just going to be right back. And remember that you're watching You and Your Right, and it's brought to you by Fortuous Solicitors. We're going to be right back. Stay tuned. Welcome back. You're still watching You and Your Right, and it's brought to you by Fortuous Solicitors. Every Monday from 7 p.m. to 8 p.m., we come your way with topical issues. Before we go on with the program, just to acknowledge few of our viewers who are watching us right now, and those that probably they are not my friends but are watching us. We greet all of you. Just to mention a few: Comfort Boatin, thanks for tuning in this evening. Salome Koi, you too, thanks for tuning in this evening. And we also want to acknowledge the presence of Promise as well. And everyone who is watching us, those who are going to watch us later on, because we know that not everyone is able to watch us live. Greetings, and please share the video to other people. Isaac and Kruma too, we greet you wherever you are. You are watching You and Your Right, and it's brought to you by Fortuous Solicitors. every Monday from 7 p.m. to 8 p.m. This evening, we were talking about, or actually, we started talking about settlement application for children and young adults. We've gone through the eligibility, people who qualify to make such an application. Before we went for that commercial break, we were going to talk about some of the considerations that the Home Office will take into before granting you the settlement concession, because as we know, it has gone through history, and the Home Office have decided, or the Secretary of State has decided, that if you qualify, amongst other things, I am going to give you settlement. You're not going to go through the 10-year route. And we also talk about benefit as well. And I think from the studios, as I can hear, we've got Lawyer Dan back with us. He had some technical challenges, but at the moment, he's been able to resolve it. Lawyer Dan, welcome back. We missed you, but we know that the last bit of this program, you're going to give us some more insight, and viewers are privileged to
Yeah.
have you. So we were talking about some of the other considerations that the Home Office will take before granting that child or that young adult settlement application. Can you take us through a bit, and obviously the benefits that they would acquire if they are granted settlement?
Thank you very much, Lawyer Patrick. As you rightly said, you give us the eligibility criteria, what you need to meet before you can even go into the process of making an application. Of course, once you have met the eligibility criteria, the Home Office do not simply make a decision to grant an indefinite leave to remain. There are further factors which the Home Office will take into account when deciding whether to grant indefinite leave to remain based on early settlement concession which was given. And the factors may include some of the things we're going to talk about, but not limited to this. There may be other things that will be considered. Of course, the person's age when they arrive in the UK is very important. We don't know what this means, but clearly, somebody who came here earlier will have a better chance of succeeding with such an application than somebody who came in later in life. So, assuming somebody came in maybe just a year before he missed the deadline, it might be an issue. But if you came in longer, then of course you have a good way, a good chance of succeeding with such an application. And of course, the length of their residence in the UK, including unlawful residence. This is very important. There might be somebody who would have been in the UK unlawfully throughout the process, may have not engaged the process to become lawful in the UK. This is very, very, very important. And this is something that the Home Office is going to look at. Of course, there might be, I will give a scenario whereby a child may have come into the UK. As soon as they came in, the parents may have attempted to apply to regularize the child's stay, but it has not been successful. And then the child straight away turns 18 and the child refuses to engage the process. This may be something that the Home Office will take a very negative view of when making consideration. But of course, once you have met the eligibility criteria, I will be very surprised if this becomes a decision that will allow them or will make not to allow you to get your stay regularized. Efforts made to engage the Home Office is also very, very, very important. So some people come into the country, they may get encountered by the UK VI, and then they may be invited to come for interviews. They may be invited to come and have their biometrics done. The possibility of you going, the possibility of you engaging the process is very important. There may be a situation where you may have been detained and they would have granted you immigration bail, and your expectation is that you will go and be reporting and you refuse to engage the process. That will also be an issue. And then you also have whether limited leave to remain will have a detrimental impact on a person's health of welfare. Whether they will grant you indefinite leave to remain or not may also depend whether if they give you a shorter period, it will affect you. And I don't know how this is because, of course, nobody is going to be excited of getting limited leave to remain instead of indefinite leave to remain if they qualify. So everybody will have an issue about those things. Then you have little issues here and there, even though we may say it's little, it also plays a very important part when the Home Office is making decision on whether to grant you indefinite leave to remain or to grant you limited leave to remain. Public interest factors are primarily concerned with an applicant's compliance with the core requirements of the immigration rules and whether they have integrated into the society. So, when making such decisions, there may be certain scenarios or situations where the Home Office might think it's not in the public interest to grant you indefinite leave to remain. There can be exceptional circumstances where something may have happened between you and your family, and the public think that it will not just be ideal situation for you to be granted. I cannot think of as an example that I can give, but let's assume a situation whereby maybe one of your parents or your family have been convicted of a serious crime against the state, and they want to grant you leave to remain, which they indefinite leave to remain, which they believe your parents may then want to rely on it to remain in the UK. This might be something that is definitely going to affect your application. Of course, they will also look at any criminal history that the person may have. Believe it or not, there might be people who are young adults but may have engaged in a lot of activities that the Home Office may consider means that they are not of good character. So they may have obtained ASBOs, they may have obtained warnings for certain things, offenses that they have committed, they may have had encounters with the police, maybe they would have run up. All these things are things that the Home Office will consider when making any application or any decision as to what they have to do. And of course, one of the key factors that the Home Office need to consider is the Home Office duty under Section 55 of the Borders, Citizenship and Immigration Act 2008. This act specifically binds the Home Office to take into consideration, they have a duty to ensure that any decision that they take is of the best interest of a child. So if they are making a decision whether to grant you indefinite leave to remain or limited leave to remain, is it in the best interest of the welfare of that child involved? And if the answer is yes, of course, the Home Office will be compelled to grant you a decision which is in your favor. And in a situation where they feel that is not the case, it may cause problems. And I can, thinking of it, which examples can I give? Let's assume a situation where a child meets the rules squarely and ideally should be granted. However, the parents, the mother, the father have been removed from the UK for one reason or the other. What the Home Office will say is that it is not in the best interest of that child to be granted leave to remain or in settlement to stay in the UK, because it is in the best interest of that child to be able to move with their parents to wherever they are going to so that they can stay as a family unit. So that is something that we need to be looking at. Of course, we can also talk about children who are under the age of 18, children who may be born on people who are on this route. I don't know whether, Lawyer PK, you want to add something to this, what I have said on the additional factors that may be considered, or if you straight want me to look at children who may be born by people who have been granted these type of leave to remain. So let's assume you have a young adult between the ages of 18 and 24, and the person has been granted indefinite leave to remain based on this new immigration rule, and that person gets a dependent child in the UK. What happens to the person? And the implications of getting the indefinite leave to remain application. Do you want me to go ahead and discuss that, or you want to come in?
Talk about
I
the
cannot
other
hear you. I don't
consideration
know.
then later on. Yeah, go ahead.
Yeah, come in, come in. I didn't hear you. I think you were muted.
Um,
What did you say?
no, yeah. So I was saying, go ahead, go ahead. We've got limited
Okay.
time, so yeah, go ahead. Yeah.
Okay, there is important to understand that people who are granted leave to remain under this immigration rule may also be able to extend that benefit to their dependent children. So, if you have a child during the time that you are granted this leave and you're going to make an application. That child may be 1 year old, that child may be 2 years old, and at that time you can make an application together with that child, and that child will be granted similar leave. So that's something very, very important people need to understand. And if after you've obtained your leave to remain, you later on go on to have a child, you can also make a similar application for that child. In effect, the child's mother or the child's other parent may also be able to benefit from this immigration rule. So this is what some people will refer to as chain migration, but it's something that it's an interesting phenomenon or factor that people ought to be aware of. The Home Office further states that it has the discretion to consider an early grant of for applicants who have not specifically raised or referred to this concession in the applications made by them or by their legal representatives. So that is something that people need to be aware of. You may not have made reference to the fact that you are making an application for indefinite leave to remain, and you have mistakenly or not knowingly made an application for limited leave to remain, even though you qualify for this basis. The Home Office may then invite you to amend or change your leave to remain for indefinite leave to remain on that basis. So that is something very interesting that we believe people ought to be aware of. But whatever it takes, it's important people get these applications right. The type of form that you complete, the fees that you ought to pay, and things like that. Of course, if you are making an application and you expect to be granted indefinite leave to remain, and you are unable to pay the Home Office fees, you may not be able to get a fee waiver for indefinite leave to remain application. This is something that people need to be aware of. Of course, if you are 18 years and you expect to be given the indefinite leave to remain, the expectation is that you meet the eligibility criteria for your life in UK test and your English language test as well. That is also very, very important. You are not going to be exempted because they've made concessions and they want to grant you this. So before you submit your application, so long as you have turned 18 at the date of an application and you are expected to get this indefinite leave to remain, make sure you have your English language requirements and then you have your life in UK test. There is also, when you consider or you look at the guidance, there is this evidential flexibility that the Home Office may give when considering such applications. So if you have made an application, there are mistakes here, you haven't submitted certain documents, and the Home Office feels that you may be, when given the opportunity, you will be able to provide those documents. The Home Office will give you the opportunity to submit those further documents with your application. But clearly, it's important that you may not get all this all the time and you may get refused, even though the expectation is that you should have been given an opportunity for you to rectify whatever mistakes that you've done. This is a typical application that I would normally highly recommend seeking professional help when considering such an application because of the nature of it, because of the private nature of it. It is difficult for you to tell which type of documents to submit as part of your application process. So, when making such an application, yes, it's private life. Yes, you need to be able to demonstrate certain factors, which we've mentioned so far. We've mentioned close to about 12 or 15 factors. So, when we have mentioned all these things, you should know that in order to meet these factors, it comes with evidence, the documentation that comes with it. And this is where professional assistance may be of use to you. So, we will strongly recommend you seek help when doing such applications. Lawyer Patrick, please come in and maybe if you can
Okay,
come your final word before we complete today's program.
okay, Layadan, thanks very much. But I also say the benefit of you wanting to make this settlement application is the fact that previously, as we know, history told us that you would have gone through the 2.5 years for about 4 times when it comes to the home office fees, the IHS fees that comes with it and everything. You would obviously be spared that huge sum of money. So if you qualify, or if you think you are eligible, you need to contact us at least to save you some application fees and IHS fees. Again, it will shorten the number of years that you'll be spending here in the UK. And obviously, if you have indefinite leave to remain, we know that the next step in the leave to remain regime in this country is you are going to be able to naturalize and get your naturalization British passport straight away. So it is very important that people take advantage of this particular concession. If you've not heard about it, I think rewind this program. If you qualify or if you are eligible, give us a call. We still do initial consultation free of charge. Give us a call. Tell us what your situation is, and if we are able to help you, we will certainly do. You've been watching You and Your Right, and it's brought to you by Photo Solicitors every Monday from 7 p.m. to 8 p.m. UK time. Thank you very much, Lawyer Dan, for joining me. Obviously, you had some technical issues, but you still head on, and at the moment, we finished the program nicely with yourself. So we thank all our viewers, our listeners, everyone who took part this evening. Obviously, our technical team as well. We thank all of you. And same time next week, You and Your Right, we will be streaming. Thanks for watching, and we will see you next week. Thank you.